Welcome to our presentation. Assalamualaikum and hi. Today my group will be present on the case Qatar versus United Arab Emirates 2019.
Hello, my name is Ruby Soidata Pamutan and my matrix number is 054940.
Assalamualaikum and selamat sejahtera. My name is Nurul Pandapati Zahiri and my matric number is 055093.
Assalamualaikum warahmatullahi wabarakatuh. My name is Rosnanita binti Rosid and my matric number is 054470.
Qatar has launched legal proceedings against the United Arab Emirates, alleging that the UAE has violated several articles of the International Convention on the Elimination of All Forms of Racial Discrimination, SE14, by implementing a series of discriminatory measures such as expulsion order and travel bans directed at Qataris based on their national origin. On 5 June 2017, the UAE has officially severed its diplomatic relations with Qatar by launching a series of coercive measures. Qatar then filed a complaint with the court on 11 June 2018 under Article 36 Clause 1 of the Statute of Court and Article 22 of SE14. Qatar claimed that the UAE's measures concerning the Qatari nationals and media corporation based on their nationality has violated the obligations under the SE14 and caused indirect discrimination against the persons of Qatari national origin. On 29 April 2019, the UAE filed preliminary objection seeking a declaration to resolve this dispute on the grounds that the court lacked jurisdiction rationale materiae as the alleged measures fell outside the scope of the SE14 and Qatar had failed to meet the procedural requirements set out in Article 22 of SE14 for submitting a dispute before the court. In this case, there are three issues that were highlighted. First of all, whether the term national origin in Article 1, Paragraph 1 of the Convention encompasses the current nationality. Second, whether the measures applied to the certain Qatari media corporations fell within the scope of the SE14. And third, whether the measures taken by the UAE are considered as being indirectly discriminatory against Qatari nationals fell within the scope of the convention. In this case, the court has decided that the phrase of national origin in SE14 did not include the current nationality. As for the second issue, the court has dismissed this issue by saying that such measures did not fall within the scope of the convention. Lastly, the court decides that the UAE's action complained by the Qatar did not result in racial discrimination against Qataris as a separate social group based on their national origin, either by purpose or by effect.
The ratio decidendi for the first claim begin where the court cited the meaning of origin, and it says that it is a person's birth connection which is connected to a national or ethnic group. Next, for the nationality, it says that it is a legal attribute which is up to the state's judgment and can change over a person's lifetime. The various phases for the definitions of racial discrimination in the SE14 Convention were also closely examined, and the court stated that the drafters were aware of the distinctions between the term national origin and also nationality. The Travel Preparatories stated that the term national origin in the convention does not cover the present nationality. The preamble of the convention were also closely examined, where the court stated that the object and purpose of this convention is to put an end to all traditions that seek to create a hierarchy among social groups. The ratio decidendi for the second claim is that the court came up with an issue, which is whether the measures against Qatari media businesses, which Qatar claims were executed in a racially discriminatory way, are covered by the convention. The court stated that the convention applies to only individuals or group of individuals in the light of the object and purpose of the convention. So, the Qatar second claim was not covered by the convention. For the third claim, Criticizing a government or its policies is not racial discrimination under SE14. This was the phrase that the court cited in coming to its decision. The measures criticized is not racial discrimination within the sense of Article 1, Paragraph 1 of the Convention, and therefore the court concluded that it lacks jurisdiction. The dicta in this case is when the court cited the case of Cameroon versus Nigeria and stated that the subject matter of a dispute is not restricted by the particular phrasing used by an applicant state in its application. It further stated that the rules of court allows an applicant state to develop on the allegations in its application as long as it does not alter the dispute brought before the court by the application into another dispute of a different character. There are no issues of altering disputes in this particular case, and thus the statement of this court is considered as dicta and it is not important in coming to the decision. For the dissenting opinion, Judge Iwasawa firstly stated that the indirect discrimination claim should be heard on its merits. He also stated what is the meaning of indirect discrimination. He states that it is the measures that are not always targeted at a specific group. It is considered discriminatory if they have an unjustifiable, disproportionate, prejudicial impact on a protected group, which is in this case based on race. Judge Saifuddin Day says that Qatar's first preliminary objection does not have an entirely preliminary objection character and should be brought to its merits. Judge Bandari and Judge Robinson stated that the notion of national origin has that historical tie to a country, and this was especially true in the case of Qataris, whose nationality is decided by paternity. Identity and national origin are inseparably connected, and in their dissent they stated that the national origin included current nationality.
Moving on to parties' argument, Qatar argues that the UAE has targeted Qatar citizens solely based on their nationality without legitimate justification, individualized hearing or consideration by imposing the coercive measure. While Article 1 Clause 2 of the SE14 gives state parties some liberties to distinguish between citizens and non-citizens, Qatar contends that the UAE has infringed its obligation under Article 2 of the SE14 by failing to take measures to prevent racial discrimination and actively engaging it and criminalizing actions that benefit Qataris. Specifically, Qatar claims that the UAE violates its obligation under Article 4 by failing to condemn racial hatred against Qatar and its citizens and instead encouraging it. In addition, it was failing to take measures aimed at combating prejudice. According to Qatar, the UAE violates further fundamental rights under Article 5 of SE14, including the rights to marriage and spouse choice and also freedom of expression. Qatar claimed that the UAE's expulsion order and travel bans as well as other measures have the intention and effect of discriminating indirectly against citizens of Qatari nationality. Furthermore, Qatar contends that the UAE has failed to offer adequate protection and remedies for Qataris seeking recourse against acts of racial discrimination through UAE courts and institutions, as stipulated in Article 6 of the Convention. Qatar contended that it is entirely legal to have concurrent proceeding prior to this committee and the ICJ, and rejected the establishment of Article 22 regarding this case. On the other hand, the UAE has issued preliminary objections to the court's jurisdiction and acceptability of Qatar's contentions. The UAE claims that the dispute between the parties and the outside of SE14's rational maritime scope, since the UAE's measure was directed towards Qatari citizens based on their nationality rather than national origin. The UAE argued that the term national origin as mentioned in Article 1 does not incorporate current nationality and that the Convention does not ban Qatari citizens from being differentiated based on their current nationality. Furthermore, before resorting to judicial resolution by the court, Qatar has not met the procedural preconditions of discussion and the Committee on the Elimination of Racial Discrimination processes. Eventually, the UAE said that Qatar's application is inadmissible since it is initiated parallel proceeding before the courts concerning the same dispute, while the Article 11 procedure was incomplete before the SE14 committee. The UAE declared the failure of Qatar to fulfill the procedural preconditions under Article 22 of SE14 in its second preliminary. Okay, that's all for me. I will pass to the next presenter.
Moving on to the critical comments, firstly, it is noticed that the court frequently refers to the convention scope in order to determine whether it has jurisdiction on each claim of Qatar. Firstly, according to the case of Georgia versus Russia, a similar dispute about the cert scope had arisen. The parties in this case disagreed over the territorial scope of cert, and the court concluded that cert does not have any territorial application limitations in order to resolve the conflict in the case. Applying to our Qatar versus UAE case, the court should not have relied on the scope of the cert convention that largely to decide its jurisdiction, and the courts chose a simpler examination of its prima facie jurisdiction rather than referring to its prior decisions. Next is, the court also adopted an extremely restricted meaning to the term of national origin in this case. Most people around the globe believe that their current nationality to be their national origin. Omitting nationality from the definitions of national origin may allow for a lot of confidential or indirect discrimination. Cert's purpose to terminate all forms of discrimination is somehow not strong, and this exclusion undermines its object and purpose. Article 1, Paragraph 2 of the CERT Convention provides for disparities between citizens and non-citizens, yet this is definitely a dichotomy. There is a contradiction where a state may limit some advantages to its residents only. In this kind of situation, non-citizens may be barred from participating. The distinctions between citizen and non-citizen is explicitly set out in Paragraph 3 of Article 1 of the CERT Convention, where it provides that states may legislate on nationality or citizenship as long as they do not discriminate any particular nationality. This is precisely what occurred in Qatari's situation, where they were subjected to travel bans and other restrictions as well. By looking at the circumstances and by Article 1, Clause 2 and 3 of the CERT Convention, it was permissible for the UAE to take measures discriminating between UAE citizens and also Qataris. However, the UAE was required to ensure that the actions served a legitimate goal and were appropriate to attaining it when adopted. Although Article 1, Clause 3 authorizes a state to enact measures that allow for nationality distinctions, it expressly states that such measure must not discriminate against a specific nationality. Qatar's dispute that the measures unfairly affected Qataris based on their nationality, which is encompassed by the phrase national origin, falls under the convention's provisions and scope.
Although the coercive measures were not merely intended against the people of Qatari national origin, but the result of such measure has implicated the Qataris, and this was deemed to constitute as indirect discrimination. However, most of the judges in this case appear to undervalue this phrase, as they indicate that indirect discrimination is inferior and not important enough as direct discrimination. It is crucial to highlight that the Qatar state claim operates independently of its claim that the measures discriminated against Qataris based on their nationality. The court should be able to discern between the first and the third claims rather than deciding that the third claim solely based on the convention's definition of nationality. Qatar's third allegation that the coercive measures discriminated against the Qataris should be able to be recognized as a protective ground that falls within the convention's provision.
In this case, the UAE's second preliminary objection is that Qatar did not comply with Article 22 of CERT's procedural procedures before approaching the court. First of all, the court must determine whether Qatar complied with one of the procedural conditions outlined in Article 22 before bringing Qatar before the court. Alternatively, suppose Qatar choose more than one option of dispute resolution. In addition, the court must assess whether the applicant is required to exhaust negotiation and set procedures before seeking relief from the court. Qatar unambiguously met the criterion of bilateral negotiation before obtaining the court. Given the preceding, the court should assess whether Qatar has required to exhaust all other procedures expressly provided for in the convention before approaching the court. The considered opinion is that this objection is not solely preliminary and can be adequately resolved after a true consideration of the proof at merit stage concerning the UAE's preliminary objection. It is based on the premise that Qatar's claim fall under the exclusions specified in Article 1 Clause 2 and hence fall beyond the rational maritime jurisdiction. That's all for me. Thank you.